Okay, so you've been named the trustee of a trust in California. Congratulations, I guess. Well, you effectively now have a job, but you do get paid for it. But if you mess up, it's a position of great responsibility, not a license to do whatever you want just because you're it. There are a ton of duties that a trustee is legally required to follow. Duty of loyalty, duty of impartiality, duty to avoid conflicts of interest, and here's a big one, duty to account. Today, we're going to zero in on that last one because in my experience, accountings are where things can get messy. And not because it's a complicated process, although it can be, but because people either don't know that they have to do it, they think they don't have to do it, or they just outright refuse to do it because they think that they can get away with it. Let me say this up front. Trust administrations are getting more contentious by the day. And when there's money involved, especially when there's real property involved, you better believe that the lawyers circling the estate will poke and prod every inch of your administration looking for something, anything to go after. Think of it with a cliche example. Imagine some sharks that smell blood in the water and they're circling, except the blood is your accounting, the shark is a $500 an hour litigator, and you're there in the middle as a trustee just trying not to get bitten. Really quick, thank you very much for watching. Be sure to like and subscribe for more info on estate planning, finances, real estate, and taxes. A like and share does go a long way in helping us get this information out there. But without further ado, let's dive into a trustee's duty to account. Let's break it down simply. A trust accounting is a report a trustee provides to the beneficiaries showing all the money that has come in and gone out of the trust, the current status of the trust assets, what the trustee has been paid, what agents have been hired, and what they were paid as well, and lastly, whether any assets were sold. According to California Probate Code 16062, a trustee must account, at least annually, when the trust terminates and when there's been a change of the trustee. The key word there being and. If it's been a year into a trust administration, then you must provide an accounting. If you close the trust 3 months later, well, there's another accounting. And if you stepped down halfway between those two time periods due to an illness and the next trustee takes over to wrap it up, that's another accounting. To be clear, that means a trustee accounting is rarely ever one and done. From experience, there are oftentimes at least two, an accounting at the 1 year mark and another when the trustee is all done and closes down the trust. The accounting also needs to be pretty comprehensive. We're not talking about scribbles on a notepad or a few vague emails. It must include all receipts and disbursements of income and principal, a detailed inventory of trust assets and liabilities, trustee and agent compensation, statements about the beneficiary's right to petition the court for a review, and a very important disclosure that claims against the trustee might be barred if not brought within 3 years after receiving the report. Essentially, the statute of limitations. This is all laid out in Probate Code section 16063 and 1060. These aren't suggestions, they are legal requirements. Going further though, this raises the question, when do you not have to provide an accounting? Well, California Probate Code section 16064 outlines some very specific exceptions where a trustee does not need to provide an accounting. First, if the trust itself says no accounting is required, which, let's be honest, most well-drafted trusts, they're not going to say that. Number two is if it's a revocable trust and the beneficiary is the person who can revoke it. Number three, if the beneficiary waived the right to an accounting in writing, not just verbally. That's very important. Spoken words mean basically nothing here. And four, if the trustee and the beneficiary are the same person. But outside of these specific exceptions, trustees must account. No ifs, ands, or buts about it. Now, what happens if a trustee fails to provide an accounting? Well, if a trustee fails or refuses to provide an accounting, a beneficiary must first send a written demand. If the trustee still doesn't provide one within 60 days, that beneficiary can file a petition with the probate court under Probate Code section 17200 and force the trustee to account. And yes, even remainder beneficiaries, those folks who aren't getting distributions now but are entitled to receive whatever's left later, they still have standing to bring that petition. And judges are increasingly siding with transparency here. If you think ignoring your duty to account is a power move, just wait until you're hit with a court order, legal fees, and potential personal liability for breaching your fiduciary duty. As I alluded to before, the winds have changed a little bit in trust administrations. They just aren't what they used to be. There was a time when people didn't really question every single little step of the process, and that time appears to be over. These days, beneficiaries are lawyered up, quick to file, and eager to object. They've been Googling or using ChatGPT. They've seen the horror stories, and if you're trying to hide something, or even if you're not, but it looks like you might be, then they'll find it. And what's worse, attorneys are getting more, let's say, creative. And if you forgot to list an account, use a vague description for a disbursement, or don't document your actions down to the T, you could be accused of a breach of your fiduciary duties. And guess what happens when you're found to be in breach? You could be removed as a trustee. You can be sued, and you can be forced to repay money out of your own pocket. Bottom line is, if you're a trustee, just do the accounting. Don't wait to be asked, don't cut corners, don't assume your family won't ask questions, because they will. And if you're a beneficiary wondering what's going on in a trust, and you haven't seen any numbers in months, or maybe even years, you should be asking questions. There's no trust administration that's so perfect, it can't go sideways when people stop communicating. And an easy way to prevent that is by just providing a thorough, timely, and clear accounting. Or perhaps a nice chat around a kitchen table, but some people like to just set some money on fire. But hey, who am I to judge? If you found this video helpful or know someone who's on either side of the accounting, please share this video with them. If you have any questions for me or a topic you want me to cover, then feel free to either drop them down in the comments below or just give me a call for a free, no obligation consultation. I'm attorney Andrew Bethel, and I'll see you at our next meeting.